pleasure to introduce Adam to everybody. Adam comes to us from Oxford. He's an associate prof there and a Garrett Tudor Fellow at Brasenose College. So I'm going to embarrass you now, Adam. Not only is Adam just like a fantastic researcher and educator, he's also a wonderful colleague to work with. So it really is a real pleasure to have you here. So Adam's going to talk about the pardon paradox, and then we'll open up for a discussion. I'll hand over to you.
Okay, thanks a lot. So thanks first to the organizers and especially to Swati for bringing me over here. And thank you all for coming. So let me kick things off with an example to motivate the discussion. And it's not an example from the UK where I'm based, or Canada where I'm from, or even Singapore, which would be great. It's an example from France. And I've chosen it because it's recent, because I think it illustrates really cleanly what interests me in the paper, and because I think it illustrates what's at stake in this discussion. So the example is about a woman named Jacqueline Sauvage. So Sauvage was married to a man named Bernard Moreau for 47 years. And for almost the whole of their marriage, Moreau abused Sauvage physically and emotionally. And the couple had 3 daughters and a son. And Moreau probably raped the daughters and abused the son. And one day in 2012, their son killed himself. And then the next day, Sauvage picked up a rifle and shot her husband 3 times and killed him. And crucially, when she shot him, he was sitting on the porch with his back turned to her. So Sauvage was convicted of murder, and we can come to the details of why in a bit. She's convicted of murder and she's sentenced to 10 years in prison. And there's a public outcry, there's outrage at her plight and her treatment at the law's hands. And the thing to know here is that under the French Constitution, the French president is granted a power to pardon. And so there's a petition to pardon Sauvage, and it eventually gains 400,000 signatures. And in 2016, President Hollande grants Sauvage a full pardon, and she's released shortly after. So that's one case, Sauvage's case. Okay. So also in 2012, also in France, a woman named Bernadette Demet shoots and kills her husband. And Demet's case and Sauvage's case are very similar. So Demet, like Sauvage, had been abused by her husband for many years. And Demet, like Sauvage, kills her husband in circumstances in which she has a physical possibility of retreating. She's not in immediate physical danger. And Demet, like Sauvage, is convicted and sentenced to a type of punishment by a court. But Demet, unlike Sauvage, is not pardoned. So I don't want to exaggerate, there are some differences between the cases, but not, I think, ones that matter for present purposes. And so these are, I want to say, like cases, which are treated differently. Now, I think for lots of people, that fact alone, like cases treated unalike, would suffice to show that something has gone wrong here, that not all is as it should be. And it's not immediately obvious how things should be. So maybe Hollande got it right in Sauvage's case and wrong in Demet's case, and he should have pardoned both women. Or maybe he got it wrong in Sauvage's case, but right in Demet's case, and neither woman should receive the pardon. We don't know. But because these cases are alike, the thought goes they should be treated alike. And I want to suggest that that's at the least too quick, and that there's a plausible argument for why these cases should be treated differently. So I'm not going to claim that there's some hidden difference here that I'm going to reveal later, and that's why they should be treated differently. I want to say that even though they're alike, it may be that they should be treated differently. Now, I don't want to make this stronger claim that in fact, the results in these two cases were both justified. That's going to depend on some details of French law, which I'm just, to be honest, not an expert on, and some facts which are going to be relevant that I don't think are clear. But I do want to say that there's a plausible argument for treating these like cases differently. Okay, so that's one of the things that's at stake. So I want you just to keep those cases in the back of your mind as we go through, and I'll return to them towards the end. Okay, so for now, I want to introduce the puzzle, or the paradox that I introduced at the start of this article. Okay. And I want to say that we can tackle this puzzle and Sauvage and Demet's case together, that they're intertwined. Okay, so this paradox, the pardon paradox, it has two branches. So the first branch is that pardon powers are extremely ubiquitous. So as far as I know, pardon powers are granted by all but 5 national constitutions around the world. I think, in fact, there's probably a case to be made for pardon powers being the most common formally granted power in constitutions of all. They're even more common than a formal amendment power. Point being, these aren't sort of relic of the past or an idiosyncrasy of the British Constitution or one constitutions associated with it. They're common, they're present in diverse constitutions. Now, what is a pardon power? So I'm taking 3 features to be central to this sort of power. Now, just to clarify, I'm not presenting these as necessary and sufficient conditions. I'm not trying to engage in a conceptual analysis of a pardon. I don't think that would interest anyone anyway. I'm just taking these features to be important and, as I say, particularly common. So first then, the exercise of this power, that's to say the pardon, it lifts or lessens, it removes or reduces liability to a sanction or punishment in a criminal context. So that's one of the things that this power does, and it's why you want the pardon. It substitutes more lenient treatment for potentially harsher treatment. And the second point is about how the power achieves that result. So a pardon power lifts or lessens liability not by altering or changing the law, not by amending legal rules, but instead by dispensing or setting aside the law in a particular case while leaving the legal rules intact for use in future cases. Third, the pardon power is held by a branch of government other than the judiciary. So in most Commonwealth jurisdictions, that's the executive. But in lots of other jurisdictions, it's the legislature. It doesn't really matter for my purposes which it is. Point being, is not a judicial power. Now, pardon powers are traditionally associated, I'll come to the current picture in a moment, but they're traditionally associated with a fourth feature too. And this fourth feature is that pardon powers are wholly discretionary. So whether to grant a pardon is at the whim of the power holder, of the dispenser of pardons. So the power holder can grant or refuse a pardon for a good reason or bad reason or even no reason. And they can follow any kind of procedure they want. They can hear from the petitioner or not. They can carefully read every petition, or they can just throw them away, all unread. There are no substantive limits. There are no procedural limits. So you can see, given this feature, why somebody like President Trump would be attracted to a pardon power. Right? There's no really clear example of unchecked power in the American legal system. No power which is as much a sort of manifestation of one person's will. Okay, so that's pardon powers. Those 3 features, and then traditionally a fourth that goes with them. Now, understood that way, pardon powers seem to be at odds with two constitutional principles: the separation of powers and the rule of law. So let me start with the separation of powers. And of course, this is a much debated principle. People argue about the content of the principle all the time. I'm not going to be talking about any of those controversial aspects. I'm going to be just talking about something that everybody, I think, can agree on, which is that judicial functions should be allocated to the judiciary. Okay, that's pretty straightforward. So a judicial function here means at least the determination of guilt and innocence and sanctions and punishments in particular cases in criminal contexts. So we give to judges responsibility for trials and sentencing for this reason. But a pardon power gives someone other than a judge a decisive say, a veto over sanctions and punishments in particular criminal cases. So, for example, President Hollande has a veto, has the ability to trump a judicial determination, even though he's really got no specialized legal expertise, and especially not in this sphere. So why is that? That's very strange on the face of it. So that's one constitutional objection. And the second is about the rule of law. So again, this is a much disputed principle, but one thing that seems reasonably clear about the rule of law is that it's opposed to totally arbitrary or uncontrolled power. So the rule of law is okay with discretionary power, so long as discretionary power is subject to general standards, so that are enforceable by someone other than the power holder. So whether to use that power and how isn't solely a matter of that person's will. And this is why judicial review is normally thought to be important for the rule of law, by subjecting discretionary powers to standards of rationality or fairness. Those powers are rendered safe from the perspective of the rule of law. But if that's how we understand the rule of law, then pardon powers seem to be a threat, because they grant to someone power which isn't subject to any external standards. These powers and how they're used are not ruled by law, and as a result, they seem to be a threat to the rule of law. So this is the pardon paradox as I see it. We've got this particularly common constitutional power, which also seems to be particularly objectionable in constitutional terms. It is part of almost every constitution, and yet by rights, it seems to really belong to no constitution. And so why is this? How should we respond to this apparent paradox? Now, just to be clear, one way of approaching this kind of issue would be through some kind of historical or political lens. We look for some kind of explanation for why pardon powers are so common. Maybe it's that people want to just aggrandize themselves and pardon power is a good way of doing that. Or maybe it's that constitutional drafters are lazy and they just copy across from existing constitutions. That may be a possibility. That's not the kind of answer that I'm interested in. I'm interested in whether there's any good reason for having pardon powers, and in particular, whether there's any reason for having this kind of power that can reconcile them with constitutional principle. Can we show that, in fact, there isn't this tension when closely inspected? So that's the kind of analysis I'm hoping for. That would be success in my terms. Okay, so I'll come to how we might tackle that paradox in a moment. But first, I just want to flesh out the legal picture a little bit. And I think this also helps to show what's at stake here, okay? Because this, how we should respond to pardon powers in their current state is an ongoing judicial issue. So I said that traditionally pardon powers are uncontrolled, and that's true, but things are changing. And they're changing because judicial attitudes towards pardon powers are changing. Now, I go through quite a bit of the case law in the article, and I'm not going to summarize all that now, I just want to highlight 2 points. So one is the trend line. So beginning in the early 1980s, courts began subjecting pardon powers to judicial review. And as far as I know, India is the first jurisdiction to do this. So in a case called Meru Ram, the Supreme Court of India began reviewing pardon decisions on a range of grounds. Okay? And since then, the Indian case law has just furthered that development. And India was the first, but many jurisdictions have followed. So just to give you one more example, in the mid-1980s, late 1970s, somewhere around then, the Privy Council said in a case called De Freitas and Benny that the prerogative of mercy, which is the traditional vehicle for pardons in many Commonwealth jurisdictions, said that the prerogative of mercy is an unreviewable act of grace, an exercise of that power is. But then in 1998, in a case called Lewis and Attorney General of Jamaica, the Privy Council reversed itself and said that no, on second thought, actually exercises of the prerogative of mercy are reviewable on procedural grounds. There's a right to a fair hearing. And then in 2017, the Privy Council didn't exactly reverse itself again, but it heavily glossed its earlier decision and said not only are they reviewable on procedural grounds, but they're also reviewable on substantive grounds. Okay. And so a steady increase in judicial willingness to supervise this kind of decision. And that's the general trend. Review in a greater number of jurisdictions on a greater number of grounds. Okay. The second thing about the case law to note is just how it addresses those constitutional concerns that I mentioned. Okay, so I said that the problem from the rule of law's perspective is that pardon powers are uncontrolled. They're not ruled by law. And judges, by subjecting pardon powers to standards of rationality and fairness, ensure that decisions about who to pardon and who not to are measured up against some standard other than the power holder's own preferences and judgments. In that way, they're ensuring that these powers are ruled by law and they're diffusing that threat to the rule of law. Now, it turns out that in judges' eyes, what these standards require is not exactly like, but something very much like trial. And so what you and there's some variation here in jurisdictions, but when we're talking about jurisdictions that are willing to go the furthest in terms of the procedures they require, what's demanded is a right to make representations, a right to a fair hearing, often a right to reasons, a right to an unbiased decision maker, a requirement that all relevant considerations be taken into account, a requirement of quality and consistency, and so on. The kinds of things that really you would expect from a judge. And so it's not that judges have appropriated this power to themselves. They haven't managed the objection to from the separation of powers that way. But they have managed it by making these power holders act more like judges. Okay? And so in this way, we're also mitigating the objection from that constitutional principle. Okay. Now, I don't want to be too critical of these judges. In general, I am all in favor of greater controls on governmental power. And I think they're not wrong to think that there's something prima facie suspicious here. But I do think that they've moved too quickly. And that they've assumed too readily that because in general discretionary powers should be subject to judicial review, that pardon powers as a discretionary power should be subject to judicial review. And what they haven't, I think, stopped to really think about is why we have pardon powers in the first place. What's the justification? What's the reason for having them? And whether that reason tells us that these powers should be treated specially. Okay. So that's what I want to explore. Why is it that we have these powers, and what does that tell us about how they should be treated? So to set out the traditional justification for these powers and then my preferred alternative, I introduced some definitions and some terms, and I've included some of the key ones on the bottom of page 1 of the handout here. So the definitions are about results and codes. So very briefly, the idea is that one result is superior to another if, setting aside the law, there's greater reason to bring about that first result than the second. And a result is suboptimal if there's some result superior to it. And similarly, one set of rules, one legal code is superior to another if there's greater reason to adopt it. And the code is optimal if there's no code superior to it, and suboptimal if there is. So I am focusing here on arguments for pardon powers, which see them as a way of correcting for suboptimal results in particular cases, of replacing bad results with better ones. So hopefully this is pretty intuitive, right? This seems like a good thing. And so if pardon powers are a good way of doing this, then that's a good reason to have them. But I am focusing more specifically on arguments for pardon powers, which see them as a way of correcting for suboptimal results, which are required by law, which are required by a legal code. But that's I'm emphasizing that because it's a fairly significant framing move in the paper. It means that I'm setting aside and not discussing a number of commonly heard arguments for pardon powers. So just to give you an example of the kind of thing I'm thinking of here, it's sometimes said that pardons might be a good way of correcting for wrongful convictions, miscarriages of justice, that kind of thing. It's found long after the fact that DNA evidence exonerates somebody. Don't we need a way of correcting for that kind of problem? Maybe the pardon power is the way. Okay, so that kind of argument is made often. It's not one I'm discussing here because that kind of result, that wrongful conviction, isn't at least probably required by law. Okay. And the fundamental reason why I'm not discussing that type of argument is that I don't think that those are persuasive. I think that a bit of digging shows that none of those arguments are very appealing. I'm happy to talk about why that is in the discussion if you'd like, but just for clarity's sake, I'm not going to be dealing with them here. Okay, so let me turn now to the traditional argument for pardon powers. And it goes something like this. So when lawmakers, when legislators come up with a set of legal rules, they're coming up with these rules prospectively. And so the rules that they are designing have to be based on the reasons that they can anticipate ahead of time. But legislators can't see into the future, and so they can't anticipate all the twists and turns that every case that their rules are going to apply to will take. And so inevitably, there's going to be some mismatch between what their rules require and what's optimal in a particular case. So inevitably, there are going to be suboptimal results. Now, were lawmakers perfect? Were they to have the ability to see into the future? Were they to have full knowledge? They wouldn't commit this kind of mistake. And so we're not talking about suboptimal results required by optimal codes here. We're talking about suboptimal results required by the inevitably suboptimal codes that we're stuck with. Okay. So this is a kind of problem. The suboptimal results that are thrown out by the limited foresight of legislators. And what should we do about these results? So on the face of it, a pardon power looks like a possible way for correcting for these results and potentially a desirable one. So a pardon power allows you to bring about a result in a particular case. And it can be used retrospectively in light of all the circumstances in a case, including all the factors that weren't available to legislators with their limited knowledge. And so it looks like the pardon power is a way of bringing about the results that legislators would have reached had they known all of the facts in the case. And as a result, it looks like a pardon power is a way of doing equity in an Aristotelian sense. And this idea that pardon powers are a way of doing equity is, as I say, old and common. So Blackstone, for example, talks about the pardon power as a cord of equity in the monarch's own breast. And modern commentators make something like the argument I've just suggested often. So this is the traditional argument for pardon powers. I confess I find its continued appeal a little bit surprising because I think on reflection it fails comprehensively. I think it fails to account for any of the distinctive features of pardon powers, which I mentioned earlier. So just to go through those briefly, I said that pardon powers are used to lift or lessen criminal liability. But legislators, due to limited foresight, can create rules which are, in particular cases, both too harsh, but also too lenient. And so if our aim here is to do equity, then a pardon power looks like the wrong tool for the job, because it's only capable of correcting for half of the problem. I said too that a pardon power doesn't alter the law. It just sets aside the law in a particular case. But if legislators, due to limited knowledge, have created rules which yield the wrong results in one case, then their rules will also yield a suboptimal result in like cases. And so the solution to the problem is going to be an exception that covers the class of case that's suboptimal. But that's not what a pardon power does. It just sets aside those rules in one case, leaving it intact for future like cases. And I said too that pardon power is held by someone other than a judge. But equity, in Aristotle's sense, is justice. It's absolute justice, Aristotle says. And if our aim is to do justice, then it's the natural thought is that we give that responsibility to not the executive or the legislature, but to judges. Don't get me wrong. It's not that I assume that judges are oracles of wisdom or are all perfect, or that they always yield the just result. But they are the ones that we rely on to get the just result in ordinary criminal contexts. And so it's, again, surprising that we wouldn't rely on them here. And I said too that pardon powers are uncontrolled, that they're fully discretionary. And again, it looks hard to explain that feature on this account. Because if our aim is to do justice, then we're aiming to do something that we have a duty to do. And so it's odd that we would create a power that includes the discretion not to do equity, which is totally uncontrolled by rules. I'm happy to talk more about these problems if you like, but I think that this argument, though traditional, is unsuccessful. And so I go on in the paper to propose an alternative, and that's what I want to turn to now. So as I see it, the better argument for pardon powers is that they are a way of correcting for some of the suboptimal results required not by suboptimal codes, but by the ones required by optimal codes. Now, initially that might sound a bit oxymoronic. Suboptimal results required by optimal codes. Wouldn't an optimal code only require optimal results? Right? And this is a common objection. So Beccaria thought that this was true, that optimal codes would only require optimal results. And as a result, he said, there's no need for a pardon power in a good code. But I think that this is not the case, and that even optimal codes will require suboptimal results. And the reason is this. So what we want from a code is something that can be used as a guide to conduct by you as one of the subjects of the law and by legal officials, and used too as a basis for predictions about how others are going to act. Now, the more accurate a code is, at least past some point, the more fully it tracks the underlying reasons in every case, the more complicated it's going to be, and the more time-consuming and effortful it's going to be to apply it, and the more likely people are to make mistakes when they apply it. And because they're more likely to make mistakes, the more difficult it will be to predict the conduct of others. All of these are costs, and as they mount up, it will often be, that we will prefer a simpler code over a more accurate one. So crude but user-friendly can sometimes beat accurate but complicated. That's the idea. So to give you an idea of the kind of rule I'm thinking of, take a speed limit. So don't drive over 50 kilometers an hour. So this kind of rule yields lots of suboptimal results. So there's some people that could safely drive faster, and probably some people who can only drive safely below that. So there are suboptimal results. And we could probably reduce the number of suboptimal results by adding qualifications to that rule so that it's more nuanced and qualified, and make special exception for particular classes of driver, or particular types of driving conditions, or times of day, or whatever. But the more complications we add to this rule, the more difficult it is to apply correctly in the moment. And the more likely people are to err when they're driving and they're trying to figure out, well, do I fall into this exception or not? And so it seems plausible that we might be better off with just a really nice, neat, clear rule that no one's in doubt about whether it applies. Okay, so my question here is, how should officials respond when an optimal code requires a suboptimal result? So what should they do? Should they adhere to the code and apply it, or should they deviate from it, set it aside in favor of some better result? Okay, they shouldn't change the code. We know that. It's optimal by hypothesis, but how should they respond? Should they adhere, or should they deviate? So I think there are 4 options, and I set them out in the middle of the second page of the handout. So let me go through them. So the first option is probably the simplest option, is say strict adherence. So we've got the best rules we can hope for, we say, and so let's just apply them, no matter what. And the advantage of this is that it succeeds in upholding the value of the code as a source of guidance and stability and predictability and all those good things. The disadvantage is that it yields lots of suboptimal results. And the I think fatal objection is that this seems like overkill. It seems that we can preserve the value of the code in terms of guidance and stability and predictability, even while deviating from it on rare occasions. So imagine that we set aside that speed limit in one case in 1,000,000, or one case in 100,000, one case in 10,000, whatever. It doesn't seem plausible that we've appreciably undermined the value of that rule in terms of predictability and stability and so on. And yet we've achieved a better result in at least one case. And so it doesn't seem like strict adherence is all that appealing. The next option is on the other end of the spectrum. Okay, and I take this to be the option that Jeremy Bentham favored. So as I've got him, Bentham favored a strategy with two parts. So we vest all lawmaking authority in the legislature, and it makes a code balancing accuracy and simplicity in the way I just described. And then at the second stage, the law applying stage, judges determine what to do in particular cases, prioritizing accuracy above all. And that means that in any case in which the optimal code designed by the legislature yields a suboptimal result, judges will deviate and they'll set it aside. Okay. And this seems to Bentham like it gives us the best of all worlds. Right? We've got this really user-friendly code, which is great, and yet we don't have to suffer any of its bad consequences because we're always going to set it aside when the result isn't optimal. So we've got simplicity and we've got accuracy, which is great. So that's the promise here. But the problem is, as Gerald Postema and others have pointed out, is that this doesn't seem all that feasible in practice. And the reason is that if judges are openly, publicly, and consistently setting aside legal rules whenever they go wrong in particular cases, then people will notice. And they won't look to the code for guidance. Instead, they'll be guided by their expectations of what judges will do. And given that what judges are doing is deciding on the balance of reasons in particular cases, and people's best guide to what the balance of reasons requires is their own judgment of them, they're not going to be guided by the law at all. And this is not ideal. Okay? So strict adherence isn't appealing, and deviation in every case in which an optimal code requires a suboptimal result is not appealing either. And so what should we do? So Bentham is insisting on a practice of deviation which is both public and consistent. So one idea is that we drop the publicity requirement. So we make a code which is really easy to follow, and we promulgate it, and we draw attention to it, and we highlight it, and tell people this is what you should follow. But then behind the scenes, judges set aside the code whenever it goes wrong. But they do this secretly. And because they're doing it secretly, and people don't know that this is what's going on, they continue to rely on the only thing that they're being told is expected of them, and that's what's in the code. And so in this way, the hope is we're getting the best of both worlds, simplicity and accuracy. So that's the idea. And I think something like this is part of Meyer Dan Cohen's idea about acoustic separation and conduct rules versus decision rules. And I'm happy to talk about the connection if you'd like. Okay, so that's one option, a sort of secrecy proposal. I think again the problem with this is about workability. If we roll this out as a general strategy, and so there are sort of two objections here. One is that it looks like it's going to be pretty hard to maintain secrecy if we've got consistency. So we're talking about judges deviating from a code constantly, and yet somehow managing to keep that totally hidden, including from the people who are benefiting from that kind of leniency. So you're breaking the law. Sometimes that's going to be clear, and yet you're consistently getting off. And yet this fact has remained hidden from you. I don't understand how that can be, at least in general. The other problem is that it's hard to understand how we can have consistency while also having secrecy. And the issue here is that if we're going to uphold this practice, we're going to need some system for monitoring and enforcing this requirement that judges set aside the legal rules whenever they go wrong. A system of monitoring and enforcing, but without the public having any idea that this requirement even exists. And so it's hard to know who's going to be monitoring and who's going to be enforcing this practice. Now, I don't want to exaggerate these problems. My argument is compatible with this secrecy strategy working in at least some cases. All I require is that it not be a strategy which works in every circumstance. It's fully generalizable. So my proposal is that instead of ditching the publicity element of Bentham's strategy, we ditch the consistency element. Okay. So the thought is that we shouldn't be adhering to the code in every one of these problematic cases. And we shouldn't be deviating in every suboptimal result case of a particular type either. Instead, we should sometimes adhere to the code, and sometimes we should set it aside. And so the hope here is that by deviating rarely and unpredictably, we'll make it so that no one can rely on the code being set aside in their cases. And because they can't rely on that, they'll rely on the only thing they can, which is the code. And so in this way, we'll preserve the integrity of the code while also getting more accurate results. That's the advantage that we get. The code's integrity plus more accurate results. The apparent disadvantage is that if we're treating cases inconsistently, then we're treating like cases differently. Now, is this irrational? I think that's a natural thought, that it's irrational to treat like cases differently. But I think that this is not always the case. Sometimes there is, in fact, good reason to treat like cases differently. So, predictability in poker is not a virtue. It's good to have a randomizing mixed strategy sometimes. You're deciding which of two sandwiches to choose, and there's nothing to decide between them. The right thing to do is not to buy both or neither, is to just pick. Often we have reasons to treat like cases differently, and here too. And the reason being that were we to treat all these cases in the same way and deviate in all of the cases, we would end up undermining the code. That would take us back to the Benthamite strategy. Okay. So and I'm calling this last strategy selective deviation. So if selective deviation is our aim, then what is the right legal vehicle or legal power to bring it about? And unsurprisingly, my answer is a pardon power in the traditional mold. So what we're looking for to execute this strategy of selective deviation is a power which is used to set aside legal rules in particular cases, but without altering them. Right? So we're assuming that these are good rules to have, they're justified rules, we don't want to change them. All we want to do is depart from them in particular cases, and that's exactly what a pardon power does. We also want a power which can't be counted on or relied on. It's never possible to predict its use or to extract it from the power holder. If you could do any of those things, if you could count on it or rely on it being used, then that's going to undermine the usefulness of the code as a source of stability and guidance. And again, traditionally, this is what a pardon power is. Totally uncontrolled by rules, totally arbitrary, totally unpredictable. So seen this way, there's a kind of irony in the rule of law. So the rule of law says normally power should be subject to general standards, and it should be subject to general standards to enhance predictability and reliability, and that's a good thing. Normally, but not with respect to pardon powers, because the more that this power is predictable in its usage, the more it undermines the rest of the rules in the system. So to preserve the rule of law, this power and this power alone needs to be uncontrolled. So the rule of law, as I see it, favors an uncontrolled pardon power over a controlled one. Now, it's not enough that we have a power which can be used inconsistently. We need a power which is going to, in fact, be used inconsistently. And so we should be giving this power we should not be giving this power to a branch of government which is institutionally disposed to make decisions consistently and coherently. We shouldn't be giving it to a branch of government which develops patterns and precedents and rules about how it makes decisions over time. So we shouldn't be giving it to the judiciary. We should be giving it instead to the legislature or the executive. And there's some other arguments for allocating the pardon power that way, which I discussed in the paper, but this is one. So seen this way, this development, this trend in judicial review gets what I think is the best justification for the pardon power wrong. What we want is a power that can be used without reason, which can be used inconsistently. In judicial review, by requiring that powers be used rationally, that there be distinguishing features when it's used and when it's refused, that they be held to general standards set out ahead of time, that's exactly what we don't want. Okay, so that's my answer to this paradox, but let me end with, by returning to this French case that I mentioned at the beginning. So just to remind you, Sauvage, she gets a pardon, but Demet, like case, doesn't receive a pardon. Okay, so why would that be? So let me just fill in some of the legal details here. So Sauvage and Demet both beaten by their husbands for many years. So their husbands were a threat to them in the past, and they were going to be a threat to these women in the future. So given that, why weren't they able to rely on a defense of self-defense? And the answer is that in France, as in many jurisdictions, one of the elements in self-defense is that the threat that you're defending yourself against is imminent or is immediate. So in Sauvage's case, her husband's back is turned when she shoots him, and so there's no immediate threat. And likewise in Demet's case, no immediate threat, and so no possibility to benefit from self-defense. Okay. Now I want to assume that the results in these two cases, Sauvage's case and Demet's case, are suboptimal. That setting aside the law, these are not the results that we would wish for. So I'm assuming that those 400,000 people that signed the petition and thought the results in that case was unjust, that they're onto something. Okay. I'm just going to take that as given. So if you think that that's right, and that these are suboptimal cases, then one question is, well, shouldn't we just change the law to avoid bringing about these results, to avoid requiring these results in the first case? And so how would you go about changing the law to do that? Well, one thought might go like this. We build in this immediacy requirement into self-defense because when a threat is not immediate, we think that people should seek help from the police or from the state, and that they should only be taking things into their own hands when they can't do that. And that's the immediacy requirement draws the line about whether you can seek help elsewhere or not. But for people trapped in abusive relationships, maybe seeking help from the state is not feasible. That's not an effective alternative for people. And so the thought might go, let's build in a qualification to this immediacy requirement for people for whom state help is not effective or feasible. Okay. That'd be one proposal. But if that's the proposal, then it's going to meet with a sort of immediate objection. And that's that by introducing this qualification to the law, we've made things significantly more complicated. We will make life more difficult for judges and, depending on the jurisdiction, for juries. We're going to lengthen trials. We're going to make the determination of this qualification, determining when it applies and when it doesn't is going to be tricky. It's going to lead to some mistakes in cases. Determining when it's available and when it's not in advance is going to be tricky. And that's going to lead to some uncertainty as to officials' conduct. All of these are costs. So let's suppose, for the sake of argument, that those costs are significant enough that overall we would do better to just stick with the immediacy requirement as we have it and not introduce that general qualification. I'm no expert on criminal law, and so I'm not in a position to judge how plausible this argument is, but it's one that's certainly found in the literature, okay, that these qualifications introduce too much complexity into the law, and we'd be better off with this clean, bright imminence requirement. So given those assumptions, we've got suboptimal results, and those results are required by an optimal rule. And so the question is, how should we respond? And if what I've said about selective deviation is right, the answer is we should not adhere to the immediacy requirement in all cases, in all suboptimal result cases. And we shouldn't deviate from it in all cases either. If we did that, that would just introduce this qualification by the back door. Instead, we should selectively deviate, set it aside in some cases and not in others. And so on this view, there's nothing irrational about pardoning some people in Sauvage's circumstances, but not all. There's nothing irrational here about treating like cases differently. And indeed, there would be nothing irrational on this way of thinking about not pardoning Sauvage and pardoning Demet. That's all I have to say. I hope that's sufficiently provocative that you have some questions.
Thanks, Adam.